This is the Walpole Zoning Board of Appeals. Tonight is Monday, December 6th. It is just after 7 p.m. We have two cases this morning, and we're also going to get some updates on other appeals that have taken place over the past year. First one we have is case number 20-21, Wall Street Development Corporation, 48 Burns Ave, and Union Street. This is on remand from the Housing Appeals Committee. Request for a project change, amendment to the comprehensive permit under Section 40B, 20-23, to amend the project to include Brook Lane, 40 units in 8 buildings instead of the previously approved 32 units in 6 buildings, and utility connections from Brook Lane, and eliminate installation of utilities from Union Street. So at this point, just so everybody knows where we're at on this, Mr. Petrozzi, the applicant for Wall Street Development, came to us months ago, and we opened the case for a major modification or a substantial modification for this project. And there was a question about peer review, and the zoning board wanted to engage a company called Tetra Tech. Mr. Petrozzi did not want to pay for Tetra Tech to do the work. Mr. Petrozzi appealed it to the Housing Appeals Committee, and then the Housing Appeals Committee remanded it back to the zoning board, saying that we could open the case, and Mr. Petrozzi has to pay to have Tetra Tech do the work. So, Town Council, did I get anything wrong on that?
You're right.
Okay. So here we are. The zoning board has already approved 36 units, and, 32 units in 6 buildings, and now we're getting a look at the new plan which includes a lot on Brook Lane.
Good evening, Mr. Chairman. Mr. Petrozzi for Wall Street Development Corp. As you've described, we are here for remand on the amended project change that we proposed back in April of 2020. Due to the COVID state of emergency, no hearings were held for that period of time. Most of 2020, the board opened a hearing in November of 2020, and we had our disagreement related to the peer review ongoing for the modifications. What I'd like to do, just for the benefit of the new members, is just go over what was previously approved and then show you the modification that has taken place since the approval. So what you have in front of you today on this plan is the proposed project that was approved by the board back in January of 2020. It's for 32 units. The major changes that are noticeable from the prior approval is the approval at that time was based with a turnaround, a cul-de-sac that the board felt might be in excess of safety measures by the fire department. So that was one issue. And then second issue was the looping of water and sewer through an access way that we have that runs with the property out to Union Street, that there was a concern from the Conservation Commission relative to the work next to the Pickerel Brook. So based on that, those changes, we engaged one of the neighbors that own property on Brook Lane. And the purpose of acquiring this property, or having an agreement to acquire this property, is to provide for a through access, eliminating the long dead-end street that was of concern, and with that, also eliminating the utility work that would have been required along Pickerel Brook with an access out to Brook Lane. The lot that we're talking about is this lot right in here. It's numbered 7 Brook Lane. It's roughly about 17,000 square foot lot with an existing single-family home on it. Of course, when you reconfigure the site, we ended up with the ability to add 8 more units to the property, to the project. Much of the project has been reviewed by the Sewer and Water, Conservation Commission, and Mass DEP has issued an order of conditions approving the site specifically the drainage that was proposed or has been proposed. And right at this point, we're ready to engage whichever peer review consultant that the board determines to be the peer reviewer. I don't think the remand order specifically requires the board
It
to
does.
hire.
It states right in the remand order, Tetra Tech.
Well, it says Tetra Tech, but it doesn't say that the board is required to hire them. Without having other bids, obviously, Tetra Tech was the only other bidder besides Beta, but my understanding of the remand order was that the board has the option of soliciting other peer reviewers in addition to Tetra Tech and Beta. So we'll leave it at that. If the board wants to engage Tetra Tech, certainly you can do that. Our biggest objection at the time was the scope of the proposal that Tetra Tech had submitted. Their proposal was to revisit the entire project from its inception, and that is not what substantial change amendment is about. The review should be just for the changes that are made to the project and not start from square one. So that's our position. So if the board has other peer reviewers that they've done business with, that they want to solicit a proposal from, that's the board's discretion, I guess.
Do you want to walk us through this new plan?
Sure. Essentially, our entrance off of Brook Lane, which would access off of Union Street and traverse through the site out to Burns Avenue, similar to what was previously approved. Burns Avenue is, as you know, a dead-end street with a private portion of the way being towards the end. Nothing in terms of the design of that intersection would change between the project site and Burns Avenue. Essentially, the private access drive would traverse through the site and exit out onto Brook Lane. The drainage that was previously proposed for the original project is essentially in the same spot. It's been redesigned, obviously, to accommodate the additional impervious surface and the comments from the town engineer and the Conservation Commission and Mass DEP. There are, as I said, 8 additional units, so the buildings have increased from 2, 4, 5, 6, 7, to 8 buildings instead of 6. The leaching area and the infiltration areas that have been previously proposed still remain in place. There is a shifting of the buildings along the, what is that? I don't know what side that is, on the northerly side, I guess, of the site. Is closer to the Gay Avenue lot line. Those units, this last building here, is a little bit closer than what was originally approved. There is, as a result of the superseding order that we received from DEP, there will be movement of a couple of units that are in what's called the riverfront area that was not requested, but was not desired by the Conservation Commission, and DEP agreed with the Conservation Commission. So there are 2 units in this general area that will shift down or be attached to another one of the other buildings. The sewer and water remains the same. We previously had discussion with the sewer and water commissioners back in 2020. They approved the project with some stipulations. I don't recall what the stipulations are at this point. It's something to do with water main connection and that sort of thing, and looping the water through the site. Mostly is what was previously done. And that's pretty much, in a nutshell, the changes to the project.
So of the 8 buildings, how many buildings have changed location? or how many, we've got 2 new ones, and which ones have changed location?
Well, the ones that were at the end of the cul-de-sac, so the cul-de-sac is no longer there, so you have 2 buildings that are in this general area, and then you have a building down here.
Okay, I'm looking at it from here, and I can tell every building except possibly the first one, as you come in on the left-hand side, has moved. Has that one moved?
Well, these 4 buildings are essentially the same.
Well, no, not essentially the same. They have moved because you already said it's closer to the property line.
This building here is closer to the property
Okay,
line, yes.
the building next to it, the first one as you come in on the left, has that one moved?
Yes, that's moved
Okay,
back a
so,
little bit too.
so they've all the configuration of all those is different than what it was before, okay. I'm just getting a feel for the scope of work, so the scope of work is going to involve looking at everything on this project, so.
Your choice.
Well, I'm just making it clear in the public record that all the buildings that moved, yeah, that's gonna change the drainage, that's gonna change any of the engineering on the site. If it moved, we're gonna look at it.
Right, but I just want to emphasize the fact that the plan has, based on your statements, that the buildings have moved and the impervious surface, that drainage has already been reviewed. That's all I'm saying, is DEP's already reviewed this plan.
And we're gonna
And
have a peer
approved it.
review it.
Okay.
Okay, board members, any questions or comments on where we're at?
Just one comment, as we move along, it's really helpful for us to see the waivers list. I know we went through one for the previous project. And just to get a sense for how the extent of the waivers, whether those are changing significantly or if they're not changing, it would be nice to have sort of a comparison of the
Sure.
extent of the waivers. If that's all right with you.
Yeah, town council, is that something that we can request from the applicant, the waivers for this?
Yes.
Okay. So we would like that, all the waivers for the project at this point.
Sure.
Board members, anything else? I'm gonna open it up to the public. Okay. Please just identify yourself, Mr. Conroy.
Good evening, Jack Conroy, owner 3436, 3840 Burns Ave. What I have here is I'll pass out to the board. And as I'm passing out, I'll speak loud enough. Everybody gets one.
Oh, okay. Even me?
I don't shout.
Particularly you.
There's been a key word on part of my little dissertation here, the word amended. So that means you're amending the previously approved plan, is that correct? What amendment means to me. Okay? I have 2 issues here that I've given you. I'll go
Excuse
back
me,
and-
Jack.
What?
Skipped.
Oh,
You skipped me.
I was counting, I thought I had
Yeah,
8. Sorry.
okay, you do.
Okay, 2 issues I got contained in here. We'll do the second one first, amended. This plan was submitted received February 13th, 2019. The previous submission that Wall Street had was for off Union Street, was for a special permit in front of this board, which the decision was dated February 21st, 2018. Very, very clear in the 40B rules that if you're a 40B and you get rejected, you can resubmit within the 1 year, but if you're anything else, which this would fall under, you'd have to wait a year. That's a difference of 8 days. I know you guys said you approved it. Has anybody granted this? Because I don't believe there is a granting authority that would allow you to accept something under a year when they've been rejected on a standard submission, which was a special permit for multifamily on Burns. That needs, right from the get-go, this probably shouldn't even have been here. It should have been just thrown or told them come back after the 365 days. So this application was filed 8 days early. So that's a major problem. Now, the second one is, right now, there's a lawsuit between Wall Street, Campbell's across the street, and myself is in front of our houses, this is a private way. We've maintained that. It is a private way. For anybody who wasn't here before, the town accepted road ends at 446 feet, which is right in front of my house at 3436 Burns. As you go down further, where the road ends, there's two pieces of property, one of which is owned by the Campbells and one of which nobody seems to know. But the house at 48 Burns has no frontage on the private way. And the piece, there's a small piece to the right when you're looking down there, it was owned by Deludis, who actually owned the whole property back in the 50s. That is set back too. That doesn't have rights on the private road. But per Mass General Law, because there was a house there at 48 Burns, they have a prescriptive easement, which means they could continue to go back and forth and we couldn't stop them. But that is only for one single house. In here, you'll find two items. One is the original filing by Wall Street against the Campbells and myself, saying he owns it, he can do what he wants, and our counterclaim. And if you look at item 21 in the counterclaim, Wall Street's legal team has admitted they have to pursue the easement. So what does that mean? Very simple. They don't control the easement. What does that mean? You can't file a plan without controlling the property. Very clear in 41B, very clear on any land type of filings. I can't make a subdivision and then think I'm going through someone else's yard. So what you have right off the bat, they have admitted in court,
Okay, hold on, you said 91, where?
no, item 21.
21.
21, okay.
Yeah, that would be the back. The first one is the filings, and the second one is the answer. And if you kind of go all the way back, John,
Yep.
and it's very simple. What it says is, Wall Street admits it intends to use the easement. So what that means right there is, he intends to use it. It's not his easement. He just says he's gonna use it. This has been submitted to Superior Court. Actually, the way it was submitted, it wasn't even with a plan. He's trying to get a what-if from the court to say, well, if I'm gonna do this, can I get a ruling? That hasn't happened. But their attorney has admitted they're going to pursue the easement. Well, you don't have to pursue an easement if you control it, if it's yours. And that's what I'm maintaining here. So my opinion is very simple, based upon not my claim, not the Campbell's lawyer's claim, but the claim of Wall Street and his law team has said, we're gonna pursue this. That means they admit they don't own it, but they're gonna pursue it in a court. Fine, then guess what? When it gets sorted out somewhere down the road, and if the Campbells and myself lose, then he can come back here. But until that time, he has no legal right to the easement, so he has no legal right to even push this in front of anybody. And that's where we are today with those two items. I would like to see what the answer is from Mass Housing on less than a year, because he didn't ask for a waiver. I don't believe they can grant it to you. I don't think they can give you a variance. And that was put in very simply, is if you get rejected on a Thursday for doing a regular, and I'm preaching to the choir, I know, but if you get rejected on something from you guys for special permit, I'll take care of that. Monday, I'm filing a 40B. No, you had a 1 year of almost like cooling off period. This doesn't even make that. So we have those two issues, both of which, the first one, my opinion, wipes out even the amendment, because you're amending an original decision. You're just continuing on with it. You approved it, but this is an amendment to it. Well, no. And also the fact that he can't do anything down there other than probably build a single-family house. So based upon what the court and what he's said in court, or his legal team has said, that's where we are tonight with this. So I expect this to just kind of like hit the skids. I know it ain't gonna happen tonight, but I'm bringing this to everybody here. So if anybody needs any more information, want another copy, George?
Good, thanks. Got it. Got the one you gave me.
Okay, that's what I came here to say. So,
Okay, thank you. Okay. So, George, we've gone back and forth about this. The access question, that's a civil case? Is that?
Yes, correct. Just to introduce myself, good evening, Mr. Chair, members of the board. George Pucci from Town Council's office. Good to be with you tonight. Yes, on that access issue, you know, it may seem counterintuitive to people who are on one side or another of that, but you really have no jurisdiction over that issue. So the applicant is an eligible applicant under the project eligibility letter. Unless and until that project eligibility letter is revoked or revised, he's still an eligible applicant. So that's how you have to treat it. You have jurisdiction over the substantive issues before you, but not to adjudicate the site access issue. That was for the subsidizing agency to pass on. They've issued the project eligibility letter, and that's what you have to go by in terms of eligibility to hear the application.
And that's because we're operating under 40B laws.
Correct.
Laws and regulations, okay. Okay, and, okay, and the other point, we did discuss this previously, the bit about the 7 or 8 days difference. Again, because they have a project eligibility, does that,
No, that really, that part doesn't, if the application was late, it was late or early. I can't speak to the specifics of it tonight because I just wasn't thinking about that issue in preparation for tonight. But I do know that that issue was analyzed before. I can speak, you know, sort of off the cuff about it is, okay.
but we did look at it, I remember we looked at it.
I mean, you can refile a 40B. So if he, you know, where that issue would really come up of, where it's of real importance is if you had a safe harbor issue at the time. So a developer comes in and, you know, they submit that application a few days too early. You go by the date of the application for a safe harbor application. There was no safe harbor issue at issue at the time, so it wasn't a matter of sneaking in the door a little bit early. And you can refile, so if the administration had found, oh no, this application is too early from the prior denial, he could have filed then the following week. It's a 40B application.
But,
You know, like I say, where the important issue comes up is you have a safe harbor, you're waiting for that determination, and a developer comes in too early with that application because they're trying to beat the safe harbor determination. That would be a different story.
okay. Anybody else from the public that wants to say anything on this? Yes?
Good evening, Mr. Chairman, board members. Kathy Campbell, 3135 Burns Avenue. Just a quick note, as Jack did refer to, there is a dispute over the alleged easement, and in no event can that easement over Burns Avenue, even if it does exist, be used to serve parcels 115 or 119 as proposed, as it constitutes overloading. 115 is Brian Martin's property at 7 Brook Lane. 119 was Walter Lasivita's property. I believe it's now referred to as the Union Street property. Thank you.
Okay, thank you. Okay.
Robert O'Leary, Washington Street. Couple of questions. Has waiver been requested for common driveways regarding this project? I heard you talk about this is a 40B project, but I thought we were going through all the bylaws that we had as well, so was a waiver requested for common driveways?
I'd have to look at the list of
Well,
waivers.
I guess my question is this plan approved? This plan is approved so far?
So, what's it, go ahead, Bob.
No, the plan that's being shown tonight has not been approved yet. We've approved the previous plan through that comprehensive permit that we issued in 2010, or 2020, I mean.
So based on the previous plan, then, it indicates in common driveways that any lots accessed by a common driveway shall never be further subdivided so as to create additional building lots. Now, I know there may be an argument on the further subdivided, but in essence, it's talking about adding additional lots, and I think that's what this plan is doing. It's adding additional lots. So I'm wondering, have they waived this requirement, and does it apply?
Well, actually, at this point, if the applicant puts that on his list of waiver requests, then that's something we'd have to consider.
Okay, well, that's my point. It's on page 76. Thank you.
Thank you. Sure. Go ahead.
Very simple. I think it's not simple. You guys are gonna have to address it, because I'll be back here. Clear cutting. He went ahead and just clear cut it, didn't have the right to do it. So we have no trees left. The whole purpose of that bylaw, which I put in back in the late nineties, was Big Y. They just, Palumbo just mowed it down. That doesn't give anybody opportunities to save stuff. That's why that was put in. So we have a clear cut, done. Now, doesn't that constitute a zoning violation, that he probably shouldn't even be allowed to be in front of you?
So, you know, that was looked at by the building inspector.
Oh, him and I had a nice little email discussion on that, and he was 100% wrong, where he allowed him to go in, and I pointed out where it said very succinctly, till he gets a building permit.
Right. And I'll be honest, I was surprised myself, because the zoning board issued a comprehensive permit, and that's what I thought was,
That's where you guys had it. Yep.
that's what we have. And the applicant clear cut all the trees, and the position the building inspector took was that that was something that the applicant was allowed to do. Not under the permit, but under the general bylaws. Town council, do you want to add anything on that?
I have nothing to add on that. There's not a zoning violation before you, I can tell you that. The building commissioner did pass on it, and you're correct. He had conferred with Mr. Petrosi to determine what, if any, as of right site work was permitted there, not under the permit that you approved, but as of right, as though he didn't have a permit. And that's how that turned out. So there was no, you know, I don't know if there was a request for a zoning determination or violation to him, if he acted on that. I don't know anything about that, but I just know that there's no cease and desist order or anything like that before you on that issue. So you would not have, regardless of the merit of that dispute, you do not have a basis to not hear this at this time based on a zoning violation.
Right. But I just want you to know that at least I'm aware of what happened.
I understand. I saw it,
and,
that's where I picked it up in yours.
Yeah.
And it's very clear, and I will say, George, like I said, I put that in the late nineties to stop this, so the building inspector had no right, you cannot issue any permit to clear cut in anticipation of a development, that's what was done. So I don't know how you're gonna address that now it's all gone. I mean, it's just amazing. The more you push, the more you cut, the more you just do this to the whole town, the more you seem to just to be able to skate. And that's what I keep seeing here. Amazing. I've been doing this 30 years, and I go by line by line by line. I uphold the law, I follow the law. And it seems like when you don't, people just run, and something like this happens. So, and there was a cease and desist on that earlier. I don't know what happened to that. It seemed to just like go up in smoke, like a lot of things have with this whole thing, so.
Okay.
Thank you.
Okay.
Cheryl Hayes Montville, 8 Brook Lane. So I own the property directly next to Brian's house. One of the things I will say tonight, and it's maybe not your fault, the transparency issue. You know, Lou owns the land. I try to not have an adversarial relationship. But the neighbors on the street, when that happened, I know some of the neighbors came down to the town, emailed the town, went to the building inspector, and everybody came back, and everybody had somewhat of a different story. The building inspector said, oh, I had a conversation with Lou. I said it was okay. You know, somebody else emailed the town. They got a little bit of a different tone. Maybe you can't control transparency as the zoning board, but I think as residents, when we all know this has been a contentious project from the beginning. I mean, I look to the zoning board. I'm not really thinking of the building inspector, because I'm looking back on all the documents that we've all gone through so many times. I don't know if you can put any words into the town administrator or somebody else, but I just feel like transparency is so important, especially like with this project, with all projects. If he has the right to do it, okay, and someone says he has the right to do it, then put it out there. Put it on the website. But that way people know, and everybody in the room and everybody in the town understands. So they're not hearing different things. Like, that had me upset when it happened. I'm like, oh, I talked to one neighbor, I hear one thing. Then I talked to another neighbor, and I heard something else. So it doesn't make the town look good at all. And as far as the project on Brook Lane goes, well, now I feel like it has pitted me against every single person on Burns Ave, because I can say, well, I don't want it in my backyard, but the people on Burns Ave have to deal with, like, the project that was already approved. So, like, I find it hard. Do I want it on Brook Lane? No, I don't. There's 4 houses on Brook Lane. Well, maybe there'll be 3. But, like, Brook Lane is gonna become Route 1, because that is gonna become a cut-through right from Pleasant Street, right over to Union Street, right out to Route 1. So, you know, I'm sure I'll be back, and I'm sure I'll have more to say, but I just think the transparency is, like, really bothersome. So I hope somebody can maybe help to make that a little bit better.
I too believe that the building inspector in general does not have any authority here unless it's an approved plan, which the first plan is. It's an approved plan, so typically he would allow it to proceed on a clear cut. You'd wonder whether he left any conditions by allowing that. Usually it's done on a limited basis that he allows cutting to take place, but not a clear cut unless it's an approved plan. However, the first plan has an appeal ongoing. So is he going to replant if he doesn't win? So I believe this board has the authority and nobody else. Thank you.
Just address that. I appreciate everybody's comments and the frustration, and just for everybody's benefit, I think, and maybe this will help towards transparency, maybe not, but the zoning board in the first instance cannot hear, an alleged zoning violation. It has to be first brought to the building inspector's attention, and the building inspector makes a decision, and if somebody's not happy with that decision, then that can be appealed to the zoning board, and then we review what the building inspector concluded, and we reach our own decision based on all the facts surrounding that particular issue. So while I'm 100% in favor of transparency, and I think as a board we try very hard to be transparent, we just don't have the authority to pull something out of the building inspector's office to review on our own. It has to be brought to their attention, they have to reach a decision, and then someone has to appeal it to the board. That's the process that is followed. Otherwise, the board acts as sort of like a roving zoning enforcement board, and that's not really what we are. We're just here to hear appeals or applications for special permits and variances and the like. So. Thanks.
Okay. Anybody else on the 40B?
Joseph Sham, Burns Ave, 28. I'm just wondering, who is in control of the start time? Is that the zoning board, or is that the building department? I know we have a rule.
So I can explain that. The zoning board of appeals issued a permit under 40B, comprehensive permit for this site. And in that, there were start times and hours of operation listed.
And those were what? Do you know offhand?
It was something like 8:30, I'm not gonna guess offhand, but we were specific, because we were looking at public safety as far as school hours and all that.
Right.
So that, that's what the zoning board put in the decision.
Okay.
The decision was filed, and that is the current permit.
So,
So, the applicant went and hired somebody to clear cut it and other stuff.
and they were backing tractor trailers all the way down Burns Ave with their backup alarms beeping at 6 o'clock in the morning.
Okay. So,
Firing up their little clear cutting machines and chippers and long before 8 or 8:30 or 9.
so, that is not in compliance with the permit that we issued. Now, the building inspector felt that that was work that was allowed outside of our permit, the zoning board's permit. So if a neighbor has a problem with something like that, it needs to be brought to the attention of the building inspector. The building inspector is also known as the zoning enforcement officer for the town. And
Well, he must have been aware of that. He must have been aware of that. Everybody in the whole East Walpole was aware of it.
okay. Probably about 3 days after it happened, I was aware of it. I wasn't aware of it that day. But one of the things, if there's a problem, people need to reach out to the building inspector, and I already heard one woman talking about transparency and everything. The zoning board, we don't work here at town hall
I understand.
every day.
I understand.
The building inspector is the person that needs to be contacted for that kind of thing.
Okay. I'm just telling you. So he wasn't in compliance there. You better be ready for him to be not in compliance when this project gets really up and running. He's gonna do it however he sees fit in doing it. And you better be ready for that to happen. He's got multiple projects in town, as you probably well know, that are not in compliance already.
Okay. Anybody else? So, next what we'll do is, we're gonna continue this, and we're going to get a scope of work from Tetra Tech. Is that what the board wants to do, is have Tetra Tech do the peer review on this?
I think that's what we agreed upon.
Okay, that's what we asked for last time. Town council, is that something you think we should vote on, to get a scope of work from Tetra Tech for the peer review that's going to include any changes on this site?
Sure, I think that's a good idea.
Would I have a motion to that effect?
So moved.
Okay. So moved by Jane. Second. Second by Dave. Bob, anything else?
No comments on the motion.
Okay. All those in favor of getting a scope of work from Tetra Tech for this? Patrick, that's what we need, right?
Yep. I've been in discussion with Sean Reid and Tetra Tech already regarding having a revised proposal.
But we don't have it yet.
What was sent to me late last week. That was actually in your packets. And so that's something that I can go back to Sean and make sure that he revised that based upon the discussion of having it be applicable only to the changes from the originally approved comprehensive permit to this new modification. In terms of what the board wants
That's
to
what I
do.
just said, yeah. It is to have any changes, so if the front entrance hasn't changed, we don't need to look at that.
Yep.
But anything that's changed, we need to look at that.
Absolutely.
Town council, that's
Yeah,
fair
that's
and
fine. Are you anticipating in your motion waiting until your next hearing date to have that proposal come back, or are you contemplating having the Pat, get that and confer with the applicant in the meantime?
We can get it, confer with the applicant, and then we can, move forward at our next meeting on that.
So our next meeting is actually next Wednesday. I don't know if that works for the board, or if we wanna wait until 2022.
Oh, I mean, if we have it, I don't wanna drag it out, but,
Okay.
but if we have it, but I need it needs to be a complete scope of work that's gonna be reviewed on this.
Okay.
Okay. So we have a motion before us, it's been moved and seconded. Any further discussion? Okay. All those in favor of Tetra Tech doing the peer review, please say aye. Aye. Opposed, abstained, so carried. Okay, very good. So now we need to talk about continuing this out.
'Mr. Campbell has to hand.
Oh, yes, Mrs. Campbell.
May I ask a question?
Sure.
I'm so sorry.
Oh, don't be sorry,
I'm sorry, Mr. Chairman. This
No
is
problem.
Kathy Campbell, 3531 Burns Avenue. May I just confirm that the proposal that we're speaking about, the Brook Lane, includes the Walpole Assessor's Map 20 lots 115, 119, 136, and 137?
One 115, 137, that's what you just said?
And 136?
That- And 136?
Correct.
Okay, yeah, and 136, yep.
Okay, so all 4 lots are on this particular plan?
Well, that's, I'm not looking at that, I'm looking at how it's noticed in the public notice.
Okay. Thank you.
Okay. What's the next available meeting?
So, next Wednesday is obviously the next available meeting. Besides that, it would be, following the board's regular schedule, either January 5th or January 19th.
What do we have on January 5th? Do we have anything?
We will have one variance request.
Okay. How's January 5th with people?
It's okay.
John, you were contemplating possibly having an executive session on that day, too.
Yep.
Do you still want to have that?
Yeah,
Yeah, so that'd be a great day for
okay,
it.
okay, good, okay. Okay. Yes,
I'm not sure I was able to hear all the conversation regarding solicitation of the proposal, the peer review proposal, but if the board were to continue this until next, the 15th, when we're here again, perhaps you'll have the peer review proposal in, and we could start the process of reviewing the plan in advance of the January 5th meeting.
in advance of what?
In advance of the January 5th meeting, in other words, when we meet on January 5th, there'll be a review completed, hopefully.
Well, I don't know if it's gonna happen that fast, but,
I'm just making a suggestion, that's
yeah,
all.
okay, we'll see where, it's, lots gonna depend on when we get the,
Right. Oh, I
the peer
understand.
review and your payment for the peer review, because we're not gonna do anything until we get your payment for the peer review.
I understand.
Mr. Chairman, just a suggestion, if the peer review quote is received before the 15th, we could continue to that date, discuss it. If not, then we just continue to the 15th until the peer review quote is received, depending on Tetra Tech scheduling. It may be able to get done within a week. But it's up to you,
No, I think the people in the public, they deserve a definitive date, not, so let's go with, the 5th. We're gonna have town council here anyways, and, if they've got the peer review, that's fine. If not, we'll discuss where we are on the peer review. Is that okay?
Yep.
George, you,
Yeah, are you thinking of a deposit being made and possible work pursuant to the peer review?
yeah, he's not gonna do work until the,
Yeah, no, I'm just saying, can that occur out
That
in
can-
the meantime if
if Mr. Petrosi drops a check off tomorrow, a blank check, so that it can be filled out to whatever amount the peer review.
And to whoever.
No, to Tetra Tech, because that's who,
Well, that's what I think what we're trying to establish, whether or not if you got the proposal before your next meeting, January 5th, whether or not if I paid the peer review.
You can start it as soon as we get the proposal.
That's all I'm saying,
Right.
that's all I'm asking.
The one thing, just so the public knows, we're gonna have a hearing on this on January 5th, and we'll see where we are as far as if Mr. Petrosi has paid, because no work's gonna be done by Tetra Tech until we have funds secured and cleared.
Procedural question?
Sure.
Do you have to vote on the scope before you allow Tetra Tech to go?
You don't have to. You can have Pat do it, or it's perfectly reasonable to bring it back for a full vote too, but you don't have to.
You know what? That's actually a good point. We need to see what the scope of work is going to be, because this is so sensitive. And in the name of transparency, I think we need to see the scope of work that's being proposed. So let's get the scope of work and payment for the scope of work, and then if the zoning board approves that, then we can go forward with that.
Okay. Yeah, that's the only reason why I brought the 15th, if I did receive the peer review quote before then. But if not, the 5th, Sean should be able to get that done.
You should be able to get the
scope
not
of
the
work.
peer review, the scope of.
Yeah, the scope of work.
And the applicant can make payment on that, and then we can move forward.
Yes.
Okay, so this case will be continued until January 5th, right here at Town Hall at 7 o'clock. Yeah, can I have a motion to that effect?
So, second.
Moved by Bob, second by Jane. All those in favor of continuing this until January 5th, please say aye. Aye. Opposed, abstained, so carried. Okay.
Thank you.
Okay. Oh, hey, Town Council, I asked you earlier about an update on some appeals that we have.
Sure.
And this doesn't affect Burns Ave, it's just some other appeals that we have going on. And I asked Town Council just to give an update while he's here on, we have 3 appeals against the Zoning Board of Appeals. KW Steel, right up over here on School Street. House lot in the floodplain on Stone Street, next to Clark's Pond, or near Clark's Pond. And finally, the solar project on North Street. So, Town Council, do you want to give us an update where we are?
Yes, on the, starting with the first one you mentioned first, KW Steel. You recall it was a zoning dispute over whether the use at 52 School Street exceeded the permitted zoning requirements in that area. That case was scheduled for trial, and there were settlement negotiations by which the operator of the business agreed to a certain set of parameters about working within the premises with the doors shut. If there was an oversized load, they would coordinate with the Walpole Police, and basically to be a good neighbor to the neighborhood, with the condition that if they vacate the premises at the end of their lease, which is February of 2022, the case would be resolved. It would be dismissed on the part of all parties. I notified the counsel for the neighbors that were most directly affected by this operation. They seemed happy with that result. The town administrator approved the settlement. The building commissioner was on board with it. The case is still pending, so if the zoning board objected to that settlement, you certainly could. In my opinion, it's a great result because the issue will become moot as of February of 2022, with KW still vacating those premises. From there, you know, the building commissioner can keep kind of a closer watch too about what happens in that building in the future, maybe require a certificate of occupancy before a new contracting operation takes place. There might be a good idea. So if the board is okay with that, we will go go ahead and, assuming KW Steel does honor their commitment, which was presented to the court, that they would be vacating by the end of February 2022, that matter can be resolved. Next one on Stone Street.
Just one question on that. So if KW Steel does not vacate, then we go back into court and,
We would go back to court, and the court would not take kindly to that, because they have clearly represented to the court that they intended to vacate by the end of February. And those cases get tried with a land court judge who is the same judge assigned to it from the beginning, so it's not like they would get a different judge. The judge is well aware that they're supposed to leave, so, like I said, she would not take kindly to that, so I expect them to honor that. Stone Street, another case pending in the land court. Basically, you'll recall, you had a denial of the construction of a single-family home in that floodplain district. The plaintiff originally filed suit appealing your decision. We agreed to a remand public hearing by which you would have peer review of the proposal. The peer review result came back with certain recommendations from GZA Environmental. The applicant did not want to comply with those further conditions. You went ahead and denied that project a second time, and they appealed again, so that's pending in court. That would be a fairly simple case to go forward with. We would need the peer reviewer from GZA to testify on behalf of the board, in support of the substantive basis for the denial. So that case is still pending. There's no trial date or anything like that, but I would anticipate that we would need authority from the town administrator to retain that peer reviewer as an expert witness and then testify as to the substantive basis of his findings. You can't charge the applicant for that as like a peer review, because now it's a dispute in court. And then the biggest one last is the solar project proposal for the Norfolk Agricultural School, actually for the county, and Kearsarge Solar. That case, we had an initial conference with the land court judge who will be assigned to it. There's a period that we're in now that we can conduct discovery, which is interrogatories, requests for production of documents, depositions, whatever we want to do to get information concerning that case from the other side. That process is ongoing, and then I think it's March of 2022, we're back for a status conference before the court, and they will contemplate some type of dispositive motion practice on that the parties will probably move for summary judgment, arguing to the court that as a matter of law, the court should uphold one side or the other. And then we'll see what happens. If the case is not resolved on summary judgment, that would proceed to trial. We would be talking about later in 2022 for that. So that's at a very preliminary stage. If you hear about witnesses or know of anybody who contacts you who wants to be a witness in the case in support of the zoning board's decision, I would recommend send that information over to me, because those cases are quite fact-specific in terms of defending the board's denial decision.
does anybody have any questions on George's update?
Thanks, George.
You're welcome. Thank you.
That's helpful. Okay. Thank you, Town Council.
You're welcome. Thank you.
Okay, Judy. Next we have case number 2119. Linda Nelbadian, 11 Mod Terrace, special permit under section 5B2 and 5B2C2 of the zoning bylaws to allow an accessory in-law suite as an accessory to an owner-occupied single-family dwelling that exceeds 33% of the total building size of the primary dwelling. And this is at Mod Terrace. So please identify yourself for the record and explain what you're proposing.
My name is Keith Nalbandian, live in Mod Terrace. My wife, Linda Nalbandian. Usually I get offended if everybody leaves the room before I speak, but this is good. I'm happy with this one. So we are gonna build an in-law apartment for my mother, with a 3-car garage underneath, expand a little bit of our house to build, office for my wife who works from home onto this while we're doing it. The 3-car garage obviously is because my wife, myself, and my mother all have vehicles put underneath. We have 1-car garage now, that'll go away, and the 3-car garage will be added on to the outside. We did ask for expansion on this, one, because of the garage, so we can put all 3 underneath and we didn't have to expand any further out. And 2, my mother's coming from almost a 3,000 square foot home. I didn't want to put her in like a 500 square foot smaller house to make it a little bit easier for her to adjust to how she's lived in for 65 years, so. So that's what our proposal is.
Okay, so let me see if we have some letters from,
There was one about the driveway. We are not expanding the entrance of the driveway. So the maximum was 24 feet. We're not expanding the front of the driveway. The driveway is gonna be the same, and it's just gonna expand a little when you get into the yard, so you can go right into the garages. So there's no expansion into the street.
okay, we'll, you're talking about the comments from the town engineer?
Yeah, the engineer, and I think the fire department had some about the smoke detectors, which will all be hardwired in on both sides of the house when we do that.
Patrick, do we have anything from Board of Health?
Board of Health,
Okay, is this on septic or sewer?
So,
So, the first one from Paul Barry, Deputy Chief. Fire Department has reviewed the plans and application of the above noted location, and we have the following comments to offer the board. If the request for special permit is approved by the board, the building plans will have to be submitted to the fire department through the building department for review, and an inspection for compliance will be conducted prior to occupancy. And we also have a letter from town engineer Carl Baldoff. He's reviewed the plans, and one, the plot plan shows an increased roof area for the proposed in-law addition breezeway and shows 2 proposed dry wells. The property is located in the primary recharge area and is over 15% impervious. Therefore, it would appear that the recharge is required to requirements outlined in section 12.3A.3D. The underground infiltration system should be required for one size for 1 inch over the new roof area. The infiltration system may be dry wells or recharge panels. Roof leaders would be installed with the inverted Y at the bottom of the downspout to provide relief in larger storms. Further, the southerly dry well should be shown in a location outside the expected driveway expansion. So, have you changed that on the plans?
no, we haven't yet.
Okay. Number 2, the right side architectural elevation shows a 3-car garage, under which will require modification to the existing driveway and increase driveway pavement. It also shows retaining walls on both sides of the driveway. The proposed driveway should be shown with increase of impervious included in the calculations, and proposed retaining walls should be shown on the plan. Is that on the plan?
Well, the retaining wall's on the left side. There shouldn't be one on the right side. It's flat.
Okay.
So there is a retaining wall on the one side. There's a retaining wall there now.
Is that retaining wall gonna stay the same, or is it a new retaining wall?
Well, it has to come down for where we're putting it, so
Okay.
they built in another retaining wall on the plans to show
Okay.
that something else will go there.
Okay, then finally, his third point was curb cut and street opening permit will be required from the DPW engineering for the driveway modification. It should be noted that the maximum residential curb cut under Walpole's regulation is 24 feet, and I saw in your plan it's 21 feet.
Right.
Okay. So,
I don't think we're actually expanding the front of we shouldn't have to cut anything in the front for the way the driveway is right now, though.
okay,
Should be big enough.
so that's gonna remain, you have a
Yeah,
21-foot opening right now?
I think there's right around 21 foot right now, yeah. So we're not expanding any of that. That should stay the same.
Okay. Okay.
You're the one for the front of the street, we're gonna.
So one of the things on this, and I did take a look at it, I'm sure other board members have taken a look at it. This is a big, almost doubling the size of the house with this, as far as livable space. Is that correct?
Yes, it's, right, our house is actually the smallest in the street, it's like 1,100 square feet, so this will put it a little over, it's like 2,100 after it's done.
So, and I know that's what one of the things you're requesting in there, that's why you're asking for a second special permit, which we don't usually see. This is, if you look at the agenda, 5B2C2, because it is over 60, I'm sorry, it's over 33%. So. Patrick, do we have any letters from neighbors, either in support or opposed to this?
I received no letters from the butters, no.
Okay.
It's funny, all our neighbors are in support of it, so they've all been asking when it's starting, because my mother comes around all the time, so it's gonna be, we were actually thinking of the neighbors when we started drawing these out, so it didn't block any corners or take up any space, so someone couldn't see around the corner when they're driving, so.
Just in terms of the interior circulation, it looks like on the first floor, you come through the main door there, and then to get into the, I guess just if you could explain sort of the flow between
course.
the existing house and the proposed addition.
So right now, the existing house, as you can see on the left-hand side where the living room is one door that's coming in to the existing house. If you look on the plan you're looking at here, the furthest stairway, the furthest door opening to the left.
Okay, all right.
That's where you come in now, goes into the living room, and you take a right down into the hallway. What we're doing is we're building a mudroom in the middle of this. As you can see in the middle now, the wider opening in the middle,
Yep.
where it'll be a mudroom. There'll be two entrances to both houses. With the doors, my mother's house, apartment's gonna be on the right, ours on the left. We have a hallway. Behind that mudroom's gonna be my wife's new office that we're building in. And then my mother's area is on the right-hand side. So the flow is gonna be the mudroom now, so it's like a common area where you walk in, everybody can take off their shoes. My mother's right on the right, we're on the left. We can flow into our house, she can go into hers.
And that, the garage is gonna be below the in-law?
Correct.
And so do you have to excavate to do that, or
It's only a little bit on the right-hand side. So where the breezeway is, the new mudroom's coming in, you're gonna excavate a little bit there, but most of the land is down underneath.
Slopes,
Yeah,
okay.
it slopes way down, so there's a retaining rock wall there now. So we'll take some of the rock wall out to be able to put in the addition, but a lot of the land is already down there, because there's a garage that goes underneath. So there will be some excavating though. And as you can see, there's no stairs going from, I know it's been a question, there's no stairs from the garage to my mother's. We have stairs that go right up and flow right into our house, where it's gonna be a hallway, she can just go right in there. So, we actually built stairs going out the back of her yard too, so we have a front and back exit for her into the backyard.
Okay, thank you.
So, on sheet A2, first floor plan, looks like there's a door from the mudroom into the main house, or has that been taken out?
Those have both been taken out into ours down the hallway and to my mother's. They've both been removed. At first, when they did the plans, they didn't remove them, but we did remove them, I think, on one of the copies. Maybe it just wasn't on all of them. But we did remove those. So it's a flow between both houses.
Any other, I mean, I've got more questions on the size, but do board members have any other questions that they want to address now? Oh, go ahead, Judy.
Okay, this is a huge addition to your house, and you already said it almost doubles the size of your property. At the same time, you're asking for like a 30% increase in what we allow for size for an in-law. And I haven't been on the board long, but you called it an apartment. I'm calling it an apartment because you get 2 bedrooms, a living room, a dining area, and a kitchen. And the ones we've seen so far that I've seen have been already, not that you can't add on, we had an addition, but we also had one that was inside the existing home already. And I get why you're trying to fit all that in because you want a 3-car garage underneath. But to me, I drove through, and when I looked at the plans, if I was standing and looking at the end of your house at your existing garage, and I was the neighbor across the way, that detail is pretty dramatic, considering all the other houses in the neighborhood of Capes with breezeways and garages, and you're already on a little bit of a hill, it looked like, so you'll be pretty far up there, I guess.
Well, the part where it's up a little bit, that's gonna be dug out, so it's not gonna be up high.
So you're not changing,
Right,
that,
right.
so
It's
the-
not changing the roof line, like,
Okay.
it's gonna be the same height as the other one. It's not gonna be higher than our existing house. It's all gonna be pretty good flow across.
so.
That was a lot of our considerations, I'm sorry, that,
Right,
you
that's
know,
okay.
trying to make
So
sure.
you have you're asking for a 3-car garage, which is allowed. So how many vehicles do you anticipate being on your property at once? Do you have older children that are gonna have cars, so above 3 cars going in the garage? Are there gonna be more cars outside?
I mean, some of our kids are at college. I have 3 kids myself, but they live with their mother. And my wife has 2, so one's at college, and then we have one that's living with us that's only 14, so.
So I guess my question is maybe kind of procedural, but has this board ever granted such a dramatic
No, and
size?
that's-
And why isn't this being filed as a variance as well as a special permit?
Because they're doing it for a, it could be as a variance of the bylaw, but where they filed for a special permit. And you're exactly right, we have never had any bit of this big. It's, and that's what I said, that's my concern. We've approved many in-law suites, but this is, you know, I checked the numbers, it's something like, right now the house is 1,110 square feet, and this is going to be, I think, 988, yeah, so.
I did the math too.
So, yeah, so, I mean, it's almost doubling the size of the house, so, and Judy, you made the point that I don't think at least, I don't recall seeing any 2-bedroom, in-law suites. So, that's something that, doesn't say you can't have a 2-bedroom in-law suite, but, you know, we gotta look at the whole bylaw. Yes, Patrick?
I just want to clarify in terms of why it's a special permit. So one, it was obviously determined by the zoning enforcement officer, but under section 5-B.2, subsection C, you'll notice at the bottom, there's kind of an asterisk, says requirements marked under an asterisk may be altered as a condition of a special permit. And so that's one of the subconditions that has an asterisk, which I believe that's why they deemed it needing a special permit rather than a variance.
So that they could do one stop for one special permit for both of them. And the zoning board would take that into consideration.
And when I read for the in-law suite or apartment, or however we call it, it said 33%, no more than 33% are no more than 1,000 square feet. So I know I couldn't go over 1,000 square feet for the addition. So if my house was bigger, I could build on a bigger in-law, correct? So if I had like a 3,000 square foot house, I could then build on something even that was almost 1,000 square feet, correct?
Correct.
Okay, but because my house is smaller, I can't,
And it's, we're looking at the character of the neighborhood. And if you had a 3,000 square foot house, it might be in a different neighborhood, because if we look at most of the houses in your area, they're comparable sizes
Yeah.
to your house right now.
well, we actually got all the numbers for all the houses. We still won't be, we'll be like the 5th biggest house in the street after the addition's on. There's still bigger houses that are in our neighborhood. So it still won't be the biggest house in the whole neighborhood after we're done. I think the house across the street from us that was looking directly at us is still bigger than his. So there are bigger ones in the neighborhood than ours.
And by the way, if you wanted to just put on a regular addition, you could put on a regular addition as long as you're not within the setbacks and.
Exactly.
You know.
Yep.
You could do that.
Right.
But you're here for an in-law
Oh, I get it.
in-law
Yep.
suite.
Right.
Okay. Anybody else have questions or comments?
I have the same concerns about the size of it, because I drove down there today too. And it really is.
We're not gonna sit here and redesign your project for you, and, because that's not what we do. But what's the rationale for 2 bedrooms for an in-law suite?
It was just, I mean, the other thing it would have been is just one massive bedroom on there. I mean, they can try to look at that and make it a huge room, but we just figured she didn't need a big room like that, break it down. We could have called that an office or a sitting room for her or anything. It's just another area from the way we set it up. It just made it easier to break it up a little bit and have the stairs go out the back to be able to go out the back door for her. Instead of going out, if you notice the stairs are in that room, going out back, instead of having the stairs in her bedroom, so she had to go out that way, it was just a little bit easier. We can take off the door and the closets, I mean.
No, we're not gonna, the other thing is, it's almost as if the 3-car garage is dictating the size of.
Well, it's not even for that. We're taking advantage for the 3-car garage being able to put the addition onto the house. So she needs a place, my mother's 80, she needs a place to go. Her house is massive right now, like 3 times the size of this. So this isn't I don't know, it's kind of a flow for her to be able to come in and be able to enjoy everything and be able to not feel like she's going from a really big house to something really small, because I think that would be a complete shock for her. But I think we've gone over the plans 100 times. We actually show it to our neighbors and everybody knows about it. We figured this would accommodate everything, because we're also putting on a small addition with the in-law. As you can see, like the office is coming out because we needed a breezeway. So we need a mudroom to come into the middle of it. So it's all for the in-law, but we actually made the mudroom coming into the middle of it just so it can connect the two a little bit nicer instead of having something go over for the ridgeline. Because if we just put on the in-law apartment, her house would have been higher than ours, so the ridge lines would have all been mixed. It would have been much taller. So we tried to keep everything same level, make it so we could, accommodate everything for what she needed.
But the neighbors all are aware of this, so,
Yep.
yeah.
Yeah.
Of course, we haven't heard anything from all of the
Haven't received any
abutters too,
comments.
which also says something that.
You may have already said, but do you have an existing garage now?
There's a under the house garage right now.
Like a 1-car garage?
Yep. Yeah. As you can, that's gonna be, where is it here? Yeah, so if you look at A3, it says storage right now. So that storage room is the garage. So that garage is gonna go away. It'll just become a storage room at that point.
And as of right now, just the two of you and one child live there in the existing three-bedroom?
Yeah, so one of the children's at college. I mean, he lives there, but he's just away at college right now.
You say you're redoing the septic too?
There's no septic.
Oh,
It's town.
sewer?
Sewer.
Are you doing anything else with the landscaping? You gonna change the landscaping layout at all, and any outside property changes?
Like what kind of change? We're not really doing anything. We're just putting the retaining wall up to accommodate for the side wall, but after that, there's nothing else going in.
Okay.
Are you changing the front walkway to the separate access point, or are you keeping it to the main part of the house?
There's gonna be a main walkway to the front. There might be a little brick walkway going over to the mudroom, but just so you don't have to walk in the grass, but there's a main walkway going up to the main room. If you look at A2, that right off the living room, there's a door. There's a walkway going up there. So you need to go over to the other one. There's probably gonna have to be some kind of small walkway going that way. But there won't be anything from the street going up to the house.
I'll just say, I've got concerns with the size of it, and it's not something that we've approved of before. How do other board members feel about the size? I'm trying to think, is this a showstopper for the board, or are people gonna say, well, can you redesign it, or what do you think?
I just think that it's gonna set a precedent to bypass all our 33, all the bylaw that you must have set it for a reason at 33%, or whichever is lesser.
Right.
And I know this is probably not the same subject, but there was something up in Winthrop Street area that the person wanted to put a garage and something or other, and it was bigger than the house. And, you know, considerably larger, and I remember the discussion, and I believe you denied it. It wasn't an in-law, that's why I'm saying it's different.
And it was a variance.
Right, but I mean, I think when you take into consideration, I'm still thinking of the word variance, even though I understand it's not filed that way. But the character of the neighborhood, the topography of the land, and like the financial hardship, or those three things jump out at you which would be a reason for asking for a variance. I look at this as, like you said, it's an apartment, what you can call it what it is, in-law suite. But I think when people have in mind an in-law suite, it's set minimum 250, in the formula. So, obviously, you probably don't want to redesign it, but, did you look at a two-car garage and a unit above that?
I mean, we've looked at all of it. We've gone through, because we were looking at the front and back of the house, the side of the house, how much, because we were following I went to the building department many times, the rules, and it was, when we looked at the 33% or under 1,000, we're trying to stick with what would benefit all of us and be able to get it, because if we came in and we just asked for a three-car garage, I mean, obviously that would have been, we could have applied for something like that off the side of the house, and then
Right.
if we had that, later on, we could have said, we want to put an in-law apartment over the top of it, and that would have almost been the same thing, so, we were looking at that. And are you not able to go over the 33%? Because when I talked to the building department, they said you have to ask for the special permit to be able to stay, you have to stay under 1,000 square feet. So we were trying to stick within the rules of what was out
Yeah.
there, but.
We can go above, but it's not something we want to do, nor should we do. And basically, I'm trying to sit here figuring out how can, what makes this a project that needs to be over 33% larger? And when I see the second bedroom in there, you know, that just is like, so why do we get a, second bedroom? You know, this is way bigger than, even in-laws that are put on attached to large houses. So that's what we're looking at. Normally, they're coming in around, 550, 650 square feet. And so what I'm seeing is small house with large in-law attached to it. That's not, the bylaw is, the whole idea is that it doesn't look like a two-family house. It looks like a single-family house. And that's the goal of the bylaw. And that's what I'm looking at, so.
Well, I think if you look at the front of the house, so with the picture, it doesn't look like a two-family house at all. Because we tried to design it so it didn't look like that, it just looked like a single-family house. I think if you drove by the house, you wouldn't think it looked like a two-family on there. It's not the way we were designing it. We try to make it so it looked really nice for the front, be able to go through, and offer.
Sure, I'll make a comment. I think relative to what Judy Conrad has said, I think I'm of two minds. First of all, the neighbors have all seen it, nobody seems to object to it. Those are the people who live in the neighborhood now. The bylaw that we have in place is meant to protect and keep the character of the town so that we don't have huge additions, much less something that's almost doubling the size of the house. And I think what Judy is saying, and I think it's a point well taken, that once we do this, anyone can come before us and say, well, at such and such a place, you let that happen. Do you see what I'm getting at? And I think the concern of one of the areas of the bylaw would be that we not find ourselves in that position. That's why it becomes a question of need, hardship, and these other areas that we would have to substantiate to another petitioner who would come before us. What you're saying in essence, and I fully understand what you're saying, that you want your mother not to come in from a big place to a small place if you can accommodate it. And I think that's that's very thoughtful. I agree. However, the next person may come and they may have the same thing. Do you see what I'm getting at? So that it dilutes the bylaw, so to speak, if we open the door and when it's not a case of need or financial hardship of any kind, it opens the door to anyone else in the town who wants to put on such a thing. I'm trying to clarify what I think Judy was saying, and I think there is some merit to that. On the other hand, the neighbors don't seem to have a problem with it, and I'm sure you've got a good relationship with them. Then on the other hand, remember this, we're looking at this now and your neighbors now. We have to look ahead and see people who come into town of Walpole. If we started this and it were to happen in a number of places, it kind of dilutes the bylaw. And that was I think that's what, I can't speak for the other members of the board, but I think that's what we're looking at here, as opposed to not liking it or not agreeing. It's more that, which is hard to get your hands around. Am I there? Judy was gonna say.
Anybody else? Okay.
Yeah, well, I hear what you're saying, and it certainly is a large in-law suite, but I do think it's pretty clear from the bylaw that we're in the world of a special permit and not a variance, and that the standards that in section 2 are really what would guide us to whether, this addition is too large or and I think it comes down to the criteria dealing with whether it will adversely affect the character of the immediate neighborhood. It looks like the rest of them have to do with vehicular traffic and pedestrian traffic, which, historically on these, we've never found a situation where adding an in-law suite was going to create some sort of vehicular pedestrian type hazard. So I think it comes down to the effect on the character of the immediate neighborhood, and that's, I think, part and parcel of the other criteria under the in-law suite section, dealing with whether it looks like a single-family home, and, you know, how does it compare with adjacent properties and things like that. So, and I think the bylaw is pretty clear that even though there's a 33%, that's sort of what the baseline limit is, that can be exceeded by a special permit. So how we decide what's too big in this case could be, you know, not necessarily reach the same outcome in another case, because it's a different neighborhood, it's a different context. But I guess, so the two things I guess I would say would be, to get a better sense for how this fits with the neighborhood, I don't know what the board would need to feel more comfortable or to clarify that. But I would agree that the plan, whatever plan we approve, shouldn't have more than one bedroom in it. Because that would be precedent setting. Somebody could point and say, well, you've approved 2 bedrooms. That doesn't really deal with the size of it. But, you know, since it is for your mother, you know, there's really, I guess doesn't seem to be a justification for more than 1 bedroom, and it suggests that more than one person's gonna be staying in the in-law suite. So I think the plans should be revised to show just a single bedroom, however you wanna lay that out. I don't wanna design it for you. But I think for the board to get comfortable with how the home fits in the neighborhood as redesigned is really the focus of whether this special permit would be appropriately granted or not.
I just pulled up your two abutting neighbors, and one has 1584 square feet and one 1632. So yes, your house is starting out smaller, but still at the end, your house is, you know, would be significantly bigger than both those. So Bob just suggested a revision of the plans. What we can do is we can continue this case tonight, because I think you're seeing there's some concerns the board has. You could come back with, is that what you're suggesting, modification of the plan?
Yeah, and I don't know what additional information the board would feel.
I do have, that's what I was gonna say.
Okay.
Additional information, if you want to provide a list of, you know, I just got 2 of them in a matter of seconds.
If you look at the house across the street from us, they just put in an in-law.
Okay.
And their house was smaller, now it's bigger too. I think you guys approved that one, which is not, I'm guessing, I don't know. What is it?
They're at 2317.
2317, so I mean, we wouldn't be much bigger than what they had.
So it, you know, so that would be helpful if we could see, you know, basically the sizes of the houses in the neighborhood. And the other thing sometimes people will also include is, you know, do they have a garage or not? Because you're asking for a 3-car garage, and I don't think there's a lot of 3-car garages in that neighborhood.
Yes, right. I think
There might be.
there's 2, yeah.
What's that?
I think there's 2.
Okay, you know, but the zoning board has to look at the character of the neighborhood. So it would be helpful if we had some more information, because at least right now, I'm leaning towards a no. And I think that if we had some more information, and particularly changing the, you know, the second bedroom is a concern, right?
Yeah, I have a concern. I think the point that Judy made about the, you know, precedent setting is a valid one, and I think the thing that concerns me the most in that regard is that it shows the 2 bedrooms. That's not something that we can say, that's not something that we can really distinguish in the future. Really what we're looking at is how it fits into the neighborhood, and any information like your neighbor's house across the street or other streets in the neighborhood or homes in the neighborhood that and how this addition fits or complements that would be really helpful, I think, for the board to make a final decision on that.
I know John had said we're not in the position to redesign your little addition here, but I would suggest you consume some of that addition for your house. make your office bigger, something so that the size of your house versus the size of the in-law suite might move down to the 33%. Do you know what I'm saying?
I do, I
Okay.
do. So, I know
I
we.
like
it
to
went
play
up and up.
architect too much. I was
yeah.
gonna be that in my prior life, but it didn't happen. But, you know, I have no problem with what your design outside looks like.
Mhm.
You know, that end looks a little big to me because the three-car garage is big.
Yeah.
When you look at 3 garage doors, but the overall concept. But if you were to like increase the size of your principal residence within the same footprint, and I'm sure your mother isn't gonna feel squished if you made your wife's office a little bigger or something like that, so that you can bring those numbers down without a drastic change.
Okay. But the office is part of the addition. That's not there right now.
Right.
Yeah, so we did pull a little bit,
But if you call it your,
yeah.
It'd be good to hear from your neighbors too, if they could write notes or even show up for the next meeting. That might-
No, I understand that. I think them not being here it says a lot too, where they're not here, so that says they, you know, we're pretty open with our neighbors and show
They're not
them
against
plans.
it, but,
They're
you know,
not against
just
it.
seeing that they're in favor and that they're not directly concerned about the size would be
So
helpful.
if I talked to them and told them to write a letter, would that be?
An email, letter, yeah.
That's a good point, Mark. Yeah. Okay, so I think a revision of your plan. The other thing is, as the 3-car garage, is this again, I'm not gonna sit here and redesign somebody's project, but 38 feet, is that what they're saying is a normal dimensions for a 3-car garage, or do you have extra room on the ends?
There's no extra room.
Okay. Okay.
That's for the garage doors, space in between, so we didn't want to make a giant door. I thought that would have looked ugly if you were looking at it, you know, one
Oh, one
giant.
door?
Yeah, yeah, so I mean, it would have been 2 big doors. I thought that would have looked terrible, so we have areas in the middle so the garage door can go up and down, and areas on the ends.
So I think you hear the concerns of the boards on the size, the 2 bedrooms. Some letters from neighbors would be helpful.
Is there something against putting, if you don't call it a bedroom, you take out the closets, call it an office? I didn't see anything, I read through it, I didn't see anything that says you couldn't have an office or a little area on something like that.
Oh. Could have an office.
Yeah.
Okay, so I can take out the closets, call it an office, pretty much.
Yeah.
I know you're saying not redesign, but I need you guys to approve it, so.
Well,
we
just
can
as
do
long as
this.
it's
So
not a
in a
bedroom.
way you
I
are.
think is all we're saying.
What's that?
Yeah.
I think as long as it's not a bedroom is all we're saying.
Oh.
You can do, you
Okay.
can make another living room, whatever you want to do with it, but as long as it's not a bedroom.
Okay, I can easily just rename, we can fix that and get that going out.
Anything else? Yeah.
So while I do, because I don't want to go back to him, the architect, multiple times, are you saying no to the 3-car garage, or is the 3-car garage, because I heard some concerns about the 3-car garage. I just want to make sure I
I'm
go with.
concerned with the size.
Okay.
I'm concerned with the size. And, you know, it's, I guess the question, when you started talking about the 3-car garage, and it almost seemed like, well, that was dictating the size of the unit, of the apartment, or the in-law suite above. Well, was it necessary to have 3-car garage, or is that what you wanted, and then everything grew from that?
Well, I think we were trying to get best of both worlds on this. It's, we needed something with more cars. I mean, between, snow and all that, being able to bring her car in and our cars in, and, there's nothing worse than shoveling off one car, so I mean, we had the room. No, I know, but what I'm saying is we had the room, and I figured we might as well get the best of both worlds where she needs a place to be able to come in. We wanted to get extra garage space, so you kind of build it all in instead of saying, I'm gonna build an in-law, and then, oh, now I wanna build a garage off the side. You kind of put it into one, so you can get it all.
And when you did that, you come up with a really big, in-law suite. So the question is there a way that you can scale it down so that you're not asking for a almost, you know, what is probably about an 80% increase of the house size. And that's just the in-law suite, not even talking about the addition of the office, which, that's not an issue. It's the in-law suite. So, what I would, you know, think probably would be a good move is for you to go back, see if you can come up with a revised plan. And also, one other thing, minor thing, take a look at the retaining wall, because if it's over a certain height, it's gonna have to be engineered. So that's a safety issue in a residential area. So just see what your height is with that. You can talk to the building inspector on that. And so the scale of it and the additional bedroom.
All right, so you want us to scale it down a little?
I'm not, you
Well,
gotta.
I
you
gotta
go
bring it back
and
in front of you, so.
What's that?
I said I have to bring it back in front of you, so I'm trying to
Yeah,
get this.
if you can, you know, if you can scale it down, it fits better with the character of the neighborhood, I think. But I leave that to you. You might come back and say, hey, can't scale it down, you know, and then the board has to decide where we go from there.
Yeah, and here are 5 other homes in our neighborhood that are this size or larger, or in this region, you know. So more than, you don't have to scale it down if it fits with the neighborhood, basically. So if you can argue that it fits with the neighborhood, then you don't have to scale it down.
Patrick?
There was something Bob and Mr. Fitzgerald had mentioned earlier regarding just kind of looking at the condition, the surrounding area, and that kind of reminded me obviously how we look at these projects within section 2.2B of the bylaw and their findings and determination. And so I don't know if anyone has their zoning bylaw in front of them, but those 8 provisions are kind of how the board needs to look at each project when it applies for a special permit, and obviously make that determination whether something fits those conditions. So.
And that's what you talked about with the traffic, the pedestrian and.
Right, and it seemed to me that the one that really was relevant here was this fitting it with the neighborhood. The others, I don't think, it's not such an intensive project that it's gonna really raise concerns regarding traffic or.
Right, yeah, it's not gonna be any more.
Right, yeah, that's, and,
Unless we put lights all over it, you know, and Griswold it up, but, you know, besides that, we'll be okay.
You can
Okay.
get on the Christmas tour.
how long do you think you'd need to get look at these questions, if necessary, get a revised plan? What's your thoughts on that?
Yeah, I can probably do it. I'll talk to the architect tomorrow and see what, if he can adjust this a little bit for us and
Okay.
see what we can do.
So, what's,
So next Wednesday, obviously, is the closest date, and then that would be January 5th. So the 15th or the 5th.
so, do you think you can get all that information by next Wednesday?
I can be pretty persistent, so yeah, probably.
Yeah, you seem like that.
Yeah, I can be pretty
That's
persistent.
good, that's good. Yeah, if you want, we can go for next Wednesday.
Yeah.
If
Well,
you
if not, can I call Patrick and try to push
and
it
then,
off?
then you'd get a continuance.
Yeah.
And we'd continue it out until January, but I'm sure you also have, you know, construction thoughts and all that.
Right.
So,
So I know 2 people have driven down the street. But has anybody else gone down to see the neighborhood or anything?
I did.
They do? All right. If you go down, there's a house on the right that just brand new in-law apartment, so it's kind of like that a little bit.
Okay.
What is the address of that?
Yeah. 12.
12 Mod?
Yep.
Okay. Okay, so, if we can continue this, you want to continue it out until next week?
I think I can get him to, I'll go over there and just sit in front of his door for a while, see what he can do.
Patrick, what does that put on for our agenda for next week?
So next week we have the continuation of the Darwin Commons, 40B, and there's also a variance request.
A what?
A variance request.
Or what address?
654 North Street.
Okay, so, I think we can handle that, next week. So, if you can get it done by then, but if not, just let Patrick know.
Of course.
And we'll go from there. Okay. So, this case will be continued until, what's the date next week? The 15th?
Yep, December 15th.
December 15th, 7 o'clock here at Town Hall.
So moved.
Moved by Bob,
Second.
second by Jane. Any further discussion? Okay. All those in favor, say aye.
Aye.
Opposed, abstained, so carried. Okay, good. And, that's it. So you good until next week? You know what you need?
Yeah, I know what I need
Okay.
to talk about.
Great.
See what I
Okay.
get done.
Thanks.
All right, thank you.
Thanks. So we have one set of minutes to review, and that's the minutes from 11/17. And Patrick, I do have one question on this.
Yes.
Who's Kevin Sanderson?
Good question. So Kevin Sanderson was recently hired in the administrator's office as a minutes clerk. Past 2 meetings, I have run out of time, and I've asked to utilize his services to take care of the minutes. I don't anticipate continuing that going forward once a new employee is found for the board secretary position. So just in the meantime, it's been able to kind of fill.
Okay.
Yep.
No, I did, the minutes were done well. Did you have any, I see you have a note there?
I just had, just a couple of
Yep.
small things. I guess on the first page, the third paragraph up where it says, starts with Mr. Fitzgerald. At the end of that sentence, it says, which the home will be after all the in-law suite. I think it should be something like, will be after construction of the in-law suite.
Okay.
And, on the second page, the fourth paragraph down, starting Mr. Delaney. That first word in the second line is,
Oh, yeah.
I think it should be R,
R.
yeah. Super substantive, I know. Otherwise, I was good with that.
Okay. Anybody else have any revisions? Could I have a motion to accept the minutes of November 17th with the 2 revisions as described?
So moved.
Anybody else? Could I have a second on that?
Second?
Second by Mark. Any further discussion? Okay. And voting on this will be, everybody, if you were here, you can vote on it. All those in favor, please say aye. Aye.
Aye.
Opposed, abstained, so carried. Okay. And George gave us an update, and then Patrick, you asked me to put this on the agenda, the master plan consultant review, interview.
Yep. The master plan consultant is the Barrett Planning Group, and so,
Is who?
the Barrett Planning
Oh,
Group.
Judy Barrett.
Judy Barrett, yep. So her team is, obviously, we just got done the first public forum and the first outreach for visioning as part of the master plan update. Her team would like to also start to review and talk to applicable town leaders about certain sections of the update. In particular for the zoning board, being a regulatory board, they wanted to kind of discuss zoning with whether it, up to you, whether you want the whole zoning board, if you want to just have a contingent of the zoning board. I just wanted to put that up to you as the chairman, if how or how many people we would want to speak to Judy and her team. And these are 45-minute to an hour Zoom interviews. And so for the zoning board, you'd probably be all in at the same time if possible. So you wouldn't be just by yourself and the consultant. So.
Okay. Is that something people would be interested in being part of, is the master plan?
Leadership interview with.
I mean, so we just do it we'd have to post it as a public meeting?
Yep.
And they're being done by Zoom?
Yep.
Okay. I'd be happy to be part of it.
Yeah, are they looking for, what kind of feedback are they looking for? Are they looking for suggested changes to the zoning or
They
something?
kind of want to know the background of what cases you've seen, probably issues and challenges you've seen within the existing zoning bylaws. I think right now it's kind of an information gathering stage to find out how are we doing, what can we change, and where are we going. And so, these, if the board wants, I'll probably send out an email tomorrow. It'd be a sign-up link through their platform. Find a time that works for you, and they'll reach back out to you with just a Zoom link, a Zoom webinar link to join them for a meeting.
But would we have all those, would it be one meeting or individual meetings?
I'd leave that up to you. I mean, if everyone's schedule's kind of mixed, I mean, they can meet with you individually, they can meet with you two at a time, but if the board wants to meet all at the same time, I would leave that
Yeah.
with you.
I'd be interested in that.
You'd like it all at once?
Yeah, I think so.
Okay. Anybody else? Mark, what's your thoughts?
I don't know if they're gonna learn from me. I'm a little newbie, so.
Okay.
Yeah, we don't have the history, the cases,
Yeah, so-
if that's what they're gonna ask about,
Right, so-
however,
So, you know, what, maybe it would be.
listen in.
It would be helpful, maybe if we do it as a Zoom meeting, so we can all sit at home.
Yep.
Comfortable, and take about an hour, you said, and we're also answering their questions, right? You know,
Exactly, yeah.
They're gonna ask questions about what we see as some of the issues, or what we've had as cases. And if you have input on the master plan, you can have a little of that. But if you have some, like, master plan thoughts, maybe you can also set up another time with Judy on your own for that.
Yeah.
Not you, Judy.
No, I know.
Judy Barrett.
It's- Usually there's not more than one Judy in the room.
So
Okay.
but that'll be a public meeting.
Public
of the
meeting,
zoning
yeah.
board.
Yeah.
We can do that on Zoom.
And we can do
Okay.
that on Zoom.
Okay.
Yes.
So tomorrow I'll send out an email to the entire group. I'll probably CC one of their consultants, and obviously the conversation we had today, here's the link for the sign up, and kind of determine what is the best date available for all of y'all.
And how do you folks feel about a Wednesday night? It wouldn't be one of our regular Wednesday night meetings, but what I don't want to do is, like, tonight's a Monday night, and I know that caused confusion for some people, but, you know, but maybe a Wednesday night would be better than other nights.
Yeah.
Judy, you good with that?
Yep, that's fine. I signed up for Wednesdays.
Mm-hmm.
That's what I signed up for.
Okay.
I have one more thing, John.
Yeah.
Could we get the filing procedure, electronic versus paper, on the agenda for discussion,
Yes.
please?
And I did reach out, so we do have a placeholder for town meeting for that.
If we need that.
And, so, so I met with Patrick, yeah, we'll
Yeah,
have
let's
it
do
on,
it, yeah.
we'll have it on,
15th?
what's that?
You want it
Yeah,
15th?
let's just put it on the 15th. What it has to do with is procedures, how we're taking cases. So, okay, good, yeah,
Thank you.
we can put that on, good. Okay, anything else? Good, we got a good update from George on pending things, and then, the only other thing, we did have the, Doopy Street, mediation, and so we'll be coming to the zoning board with that for a, what did they say, we'll do that as a
Well, they're
discussion.
gonna prepare some additional information, and then, yeah, then the board will discuss it.
Yeah. Okay.
All right.
Anything else? Could I have a motion to adjourn?
So moved.
Moved by Jane. Second by Dave. All those in favor?
Aye.
Opposed, abstained, good night.